But I'm now very pleased to begin today's activities with a keynote presentation by Professor Zhang Wanhong. We're very honored to have him joining us. The session will be chaired by Professor Carole Petersen from the University of Hawaii, and I'll now hand things over to Carole to introduce Professor Zhang.
Thank you, Kelly. And I apologize in advance. My voice is a little hoarse. I've got some hay fever today. But I am thrilled to be here and so pleased that you asked me to introduce Wanhong. Professor Zhang earned his PhD in law from Wuhan University School of Law, where he now holds the position of Professor of Jurisprudence. He is also the director of the very important Wuhan University Public Interest and Development Law Institute and of the Wuhan University Institute for Human Rights Studies. He is truly a pioneer in rights-based disability studies in China, and he is the founding editor-in-chief of Disability Rights Studies in China. He is also one of the drafters and evaluators of China's several national human rights action plans. Professor Zhang truly has an international reputation. In 2005, he served as the Edwards Fellow at Columbia University School of Law in New York City. In 2013, he was named as Columbia's first Greater China Public Interest Fellow. He has also held visiting positions at several academic institutes around the world, including the Norwegian Center for Human Rights, the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden, the Danish Human Rights Institute, and Academica Sinica in Taiwan. He is also a senior research fellow at the Netherlands-China Law Center at the University of Amsterdam. He is probably best known for his work in disability studies. Professor Zhang has held many important positions, not only in the field of academics, but also in policymaking. He has served as the vice chair of the China Disability Research Society, the associate director general of the Hubei Provincial Disabled Persons Federation, and deputy chairperson of the Hubei Provincial Disability Research Society. And finally, I would like to add, on a personal note, Professor Zhang has hosted numerous training conferences at Wuhan University in disability studies. I've had the pleasure, and so has Kelly and other people at this conference, of attending and participating in those conferences. And I have to say, he is a warm and welcoming host. And I can tell from his manner and the way he interacts with people at these conferences that he has inspired probably thousands of disability rights academics and activists in China. So with that, I welcome you, Wanhong, and we're really looking forward to your keynote address. Over to you.
Thank you very much, remarks, and make me to remember the wonderful days we stayed together in Hong Kong and in Wuhan many years ago. Hopefully, we'll have an in-person meeting in the future. And thank you to Kelly and David for organizing this excellent event. I'm honored to speak here. Today, my topic is from disabled justice to disability justice, based on my observations and practice in China. Let me share my screen with you. As observed in almost all human societies, persons with disability have experienced long-term disabled justice. As Professor Flynn, her famous book published several years ago, they are not recognized as legal subjects with equal capacity, suffer from prevailing prejudice and discrimination, substitute decision-making laws, social segregation and exclusion, exploitation, and abuse in institutions and other places. It consists of a common challenge in disability rights for the world, not only by a denied distributive justice, but also the ineffective access to a judicial remedy. It therefore asks for reflections on the spheres of disabled justice and explores new approaches to disability justice. When protecting disability rights and implementing the CRPD, China has confronted the same challenges as other states. It has taken similar legislative reform to tackle the discrimination against the persons with disability, but also earned unique experience, which would deepen the understanding of human capabilities, people as free, equals, and access to justice. This presentation will take from this practical experience and show two critical points of disability justice, namely the structural reform for substantive equality, including legal, political, economic, and cultural efforts. Secondly, the individual agency from diverse capacities performed in the engagement among disability communities, researchers, and policymakers. Here I use voice, ideas, and policy to refer to the communities, researchers, and policy makers. In the first part of my presentation, let me give my reflections on the spheres of disabled justice. In the legal dimension, persons with disability are not recognized as legal subjects and suffer from the prevailing substitute decision-making laws. Persons with a disability are considered unable to perform autonomously and thus excluded as legal subjects. All persons with disabilities, particularly those with mental or intellectual disabilities. I saw the friends from the Chosen Power, Emily, and their colleagues are here. So the persons with disability, particularly those with mental and intellectual disabilities, could suffer from the denial of legal capacity and be subject to substitute decision-making and abuse. The misunderstanding and misuse of adult guardianship for persons with disability have led to a broader range of discrimination on the ground of disability. For instance, in 2017, a deaf client in my city and her legal aid lawyer was rejected by a local court to launch a civil litigation because the court staff asked the client's guardian to represent the litigation. The lawyer argued that her deaf client was an adult and has no need for a guardian. But the court staff replied, all persons with disability need a guardian to litigate. Moreover, persons with a disability are denied their legal capacity in many other areas. For instance, the bank refused to issue a debit or credit card to persons with disabilities. Due to communication difficulties, a civil affairs bureau declined marriage registration for a deaf couple. Insurance companies rejected contracts with persons with disabilities, and health care services neglect the informed consent of persons with disabilities. Those are stories that happen around us. The Committee on the Rights of Persons with Disabilities has repeatedly emphasized that persons with mental or intellectual disabilities are entitled to equal capacity for autonomous decision in all case areas, including equal competence in a lawsuit. However, different jurisdictions have responded to the Article 12 of the CRPD differently with controversy. The implementation of Article 12 is also interweaved with the Article 13 on access to justice. The cases mentioned above denied persons with disabilities legal capacity. Some find remedies through tort or contract lawsuits, but some would find no legal grounds to support a judicial remedy. It further requires the analysis of political, economic, and social dimensions. Secondly, I will talk about social segregation and exclusion are dominant in the political and economic dimension, and the exploitation and abuse in institutions and other places happen frequently. The segregation and the exclusion of persons with a disability in education and employment is particularly severe. And I will not wordily describe this issue. As for persons with disabilities, the care they need has a unique vulnerability and increases the risks of rights violation. In families or institutions that provide care services, neglect and abuse could be appealing. Article 16 of the CRPD particularly calls for party states to note that the facilities designed for caring for or protecting persons with disabilities could be the causes of right violation. The segregation and absence of monitoring leading to care providers' abuse of power. Article 16 also clarifies that the mistreatment of persons with disability frequently happens in close relationships within or out of families. It thus extends the state obligation to protect beyond the scope of institutions and covers more expansive areas such as domestic violence. It should be noted that Article 16 does not say on an equal basis with others, which appears in all the substantive rights provisions of the CRPD. It means the favorable treatment of persons with disabilities and justify the state intervention in private life. Nevertheless, this affirmative response to prevent harm or risk to persons with disabilities shall not lead to any social segregation or the rise of paternalism. It opens the political and economic dimension for disability rights protection to cope with this challenging issue. It urges the public to review the distributive justice of basic goods through specific personality and personal safety laws. It also recognizes the agency of persons with disability in public participation and provides support to their capabilities. In the cultural dimension, the deepened roots, prejudice, and discrimination have exacerbated the injustice experienced by persons with disability as less worthy other. Underlying the institutional discrimination and unfairness in the cultural prejudice, persons with disability have perceived as the other in the world of philosophers such as Jacques Derrida, Michel Foucault, with less social recognition. In some scenarios, persons with a disability seems to be a remote other and lacks essential human ability. As for John Rawls, a model person must have the capability of having a conception of their good and of having a sense of justice to a minimum degree. But persons with a severe body of mind disability could be perceived as having no such abilities and thus an alien of humanity, a less worthy other. In some other scenarios, persons with a disability seems to be a close other who looks normal, but the general public finds them abnormal during close communication. Persons with mental or intellectual disabilities and deaf people could be found disgusting or terrifying by some, I would say, general public. As a Japanese writer, Masahiro pointed out in his uncanny valley theory, some cultural sociology studies on this would help reveal the dilemma of psychological and cognitive elements in disability identity. It needs to combine the efforts of science education and human rights education to raise awareness for disability equality. Some cultural anthropological studies on risk and vulnerability also shows the stereotype of the ideal body in Western society. It considers a bourgeois, male, heterosexual, able-bodied, white body as the best fitted to the idea of reasonable, self-restrained, and civilized. In contrast, working class, female, LGBTI, disabled, and non-white bodies are considered emotional, unstable, violent, and chaotic. Due to this prejudice, A court would hold persons with a disability more liable for personal injury in a traffic accident, as they should have paid more attention to avoid the high risk caused by their own flawed body or mind. In the context of international human rights standards, disability identity directly pertains to the cultural rights of persons with disability. Article 13 of the CRPD articulated persons with disability shall take part on an equal basis with others in cultural life, and includes sign languages and deaf culture in the cultural and linguistic identity. The full enjoyment of such cultural rights is crucial to cultivating self-confidence and autonomous among persons with disabilities, establishing a supportive network for individual fulfillment and a forum to influence public opinion, raise awareness, and eliminate prejudice. In brief, the spheres of disabled justice show the challenges of distributive justice confronted by persons with disabilities. In terms of economic resources, cultural recognition, public participation, and other public goods, persons with a disability have been considered less worthy. They are disadvantaged, trapped by powerlessness, and limited to meaningful choices in life. It against the sense of justice and fairness in nowadays civilization. Moreover, the flawed corrective justice has worsened the protection of the rights of persons with disabilities. The existing judicial system is filling with barriers for persons with disability to launch a litigation, effectively participate in court proceedings, and argue for appropriate remedies. It is essential to reclaim the principles established by the CRPD, such as substantive equality and procedural accommodation, uphold the inherent dignity and the diverse capacities of persons with disabilities, and improve the institutional approach to actual cases of injustice. In the second part of my presentation, I will propose a new approach to disability justice, from the 4 dimensions of substantive equality to the golden triangle of the implementing the CRPD. Yesterday, we had Professor Sandra Friedman's book talk. She famously has proposed the open frame to pursue substantive equality that consists of 4 dimensions in her another book. Following this theory, the Committee on the Rights of Persons with Disabilities has advised an idea of inclusive equality in their General Comments number 6 in 2018 on equality and anti-discrimination, which is very similar to the substantive equality we discussed here. In the practice of China implementing the CRPD and other human rights standards, it has also emphasized the substantive equality of persons with disabilities and comprehensive to the frame of substantive equality to understand the disability justice and review the CRPD implementation. My argument for disability goes beyond legal research, such as how to define disability and regulate indirect discrimination against the persons with disability in domestic laws. It is undoubtedly essential to have this institutional reform, and legislative change indicates the milestone progress. However, to better redress the implementation gap for the CRPD and the domestic laws, we need to pay attention to the following questions. When human rights standards and national laws enact and denial of reasonable accommodation as discrimination against the persons with disabilities, what does it mean in all the social areas? It may lead to an ongoing war of paradigms, of ideas, but not simply a quick paradigm shift. The arguments for distribution of resources, justification for cause of accessibility under the dilemma of judicial ruling to combat ableism prejudice. In the last 2 days, we have a conference organized by the UN Asia Pacific region office in Bangkok on the final review of the decade of disability in this region. We discussed the idea of anti-ableism very deeply, and that's the main theme of the conference. With how to combat the ableism prejudice and the interlinked and need to be tackled in a practical approach. I will use examples from China to illustrate how to pursue substantive equality for the persons with disabilities. On the screen, the 4 dimensions of the substantive equality proposed by the Professor Sandra Friedman: the resources, politics, laws, and awareness. That's the 4-dimension framework I would say invented or proposed by the Professor Sandra Friedman. In her article, Substantive Equality Revisited, the International Journal of Constitutional Law 6 years ago. And also, I think that this framework was followed by the General Comments number 6 of the CRPD committee. Firstly, in the cultural dimension, the primary goal of disability rights is to restore the human in human rights. According to Professor Sandra Friedman, the cultural dimension speaks to our basic humanity and redress stigma, stereotyping, and segregation. It focuses on raising awareness of human diversity, recognizing interdependence among social members as equal others, and claiming just conditions for inherent dignity. To restore the human part in the conception of human rights, we need to start with the critics of the social model of disability rights and applying a universal vulnerability approach to reinterpret human rights, pursue international reform, and argue for the human diversity. This approach takes the human person as a needy or immattered being who has to act with social relationship and rules. There is no such inherent individual disability or limitation, but the interaction of diverse human capabilities and unjust social institutions. In Chinese, just in recent years, I and my colleagues do not use the term vulnerable groups, 弱势群体, to describe structurally disadvantaged persons such as women or persons with disabilities or elder population, but a more neutral phrase, particular groups, or 特定群体. This would be a raising approach to understanding human rights in our society. The social model of disability has learned from England's materialism and empiricism tradition to criticize the inequality caused by economic and social structure. People in China are more familiar with Karl Marx, the Marxist materialism. It shares the same critics towards the inequality constructed by the external environment. Still, it stresses the tyranny of the meritocracy and the underlying ableism in capitalist society. The China practice tries to balance the pursuit of efficiency and fairness and pays more attention to the human ability to make and use tools in our context, including assistive tools for persons with disabilities, that embrace the diversity of humanity from a materialistic approach. This approach recognizes the limits of the formalism, rule of law, and dedicates to substantive equality through the combination of law and morality. According to this practical materialism, the agency or subjectivity of persons with disabilities derives from the fact that a human being is an embodied being with a human mind that carries social relationships and creates human history. As noted in the China Human Rights Discourse, disabled people are equal members of society and an important force for the development of human civilization and for upholding and developing Chinese socialism. This is also a positive interpretation and application of the people-first approach of the China Human Rights Discourse. China has explored a path of its own to respect, protect, realize, and develop the human rights of peoples, and this cultivates a common sense of justice to protect the inherent dignity of persons with disabilities. The Human Rights Discourse established in the White Papers in the 1991 and the National Human Rights Action Plans since 2009 has attached significant weight to the equal protection of particular groups such as persons with disabilities. More evidence could be found, such as language used in domestic laws and the policy has changed from 残废, literally in Chinese means disabled and useless, to 残疾, that means disabled and impaired. The communities and the majority of policymakers have also accepted the term 残障, the persons with disabilities, since ratifying the CRPD in 2008. On the International Day of Persons with Disabilities in 2021, last year, China Central Television has released a series of widely disseminated posters that recognize the equal dignity of persons with disabilities, call to stop alienating them, and promotes social inclusiveness. In the political and the economic dimension, equality, participation, inclusiveness, and shared citizenship for persons with disabilities have been included in the national reform agenda. There's a second point I want to share. In Friedman's four-dimensional concept of substantive equality, the structural constraints of social economic disadvantages and powerlessness shall be redressed by a just distribution of resources and a rebalance of rightful claims through effective participation of marginalized groups. It requires the re-politicalization of those underrepresented or neglected issues related to disability equality and better community empowerment and the engagement for disability policy advocacy, reform, and implementation. The People's Republic of China and its leading party, the Communist Party, upheld its socialist ideology to care for and protect the grassroots and powerless people. In the past 70 years, sustained social and economic development, the national poverty reduction, and the shared citizenship for all people have become one of the most significant achievements of Chinese government. Meanwhile, the progress towards the rule of law in China has paid particular attention to equal protection and positive measures for the basic goods and the liberty of persons with disabilities. In 1990, the law on protection of disabled persons was enacted in China to initiate a nationwide legal protection system. In 2008, I mentioned before, China ratified the CRPD, and then the law on protection of disabled persons was amended with further emphasis on eliminating discrimination on the grounds of disability and constructing an accessible environment. Increasing administrative and provincial regulations have been introduced to implement the new laws in the past 30 years. Several prominent political events have also shaped and enhanced the advocacy for disability justice in China. The current leadership of China has been familiar with disability affairs through major national events such as 2008 Beijing Olympics and Paralympics, And this year, 2022 Beijing Winter Olympics and the Paralympics. Another practical approach to implementing the legal rights of persons with disabilities in political and economic dimensions is the enactment and the performance of the National Human Rights Action Plans. The 4 terms of the National Human Rights Action Plans since 2009 have demonstrated the political will to respect human rights and protect the substantive equality of disadvantaged groups, such as persons with disabilities. Number 3, in the legal dimension, accessibility and reasonable accommodation have been legislated as the newest or latest institutional promotion for substantive equality. Referring to the framework of Sandra Friedman, substantive equality for persons with disabilities contains both distributive justice and corrective justice in the legal dimensions. It starts with the legal requirements for accessible environment and accommodation to eliminating external barriers, change social conditions, and respect the diversity of human capacities in all the social areas. The legal accommodations, therefore, shall go beyond the dichotomy, the exceptionalism, and the radical structural changes for substantive protection of equal rights. It recognizes the unique vulnerabilities and risks faced by persons with disabilities, respects their legal capacity with institutional support and procedural adjustment, and guarantees their meaningful choice in education, employment, and other areas through public service equality. Inspired by the achievements of the disability cause in China, the public interest litigation campaign has included accessibility issues. The new legal aid law in 2021, last year, creates a separate provision to ensure accessible public legal services. The National People's Congress is drafting a new law on constructing an accessible environment. The Supreme People's Court, the Ministry of Justice, also jointly issue a strong opinion on the equal judicial protection of each person with a disability in all the stages of legal proceedings in this March. Accessibility, including procedural and reasonable accommodation, has been the most outstanding contribution of the CRPD to disability justice. It enlightens us to pursue a rule of law system towards social resilience and solidarity. Social resilience consists of the capacity of each social member to resist harm, adapt to change, and recover better from a crisis. 韧性 in Chinese, or 复原性. Solidarity derives from the recognizing human dignity and the inclusion of a human diversity for the most disadvantaged social members. Therefore, promoting the comprehensive protection of human rights in a society with the rule of law, empowering each social member through legal accommodation, and fulfilling the capabilities of persons with disability constitute the legal pillars of inclusive equality and disability justice. That's the first part of my approach introduction, and the second part of my proposed approaches is the golden triangle of implementing the CRPD. I call it the VIP model: voice, ideas, and policy. The emancipating force of the CRPD has learned a lot from the previous practice of human rights campaigns, such as the civil rights and the feminism movements, concluded the best practice of other human rights bodies, and included the advocacy of global disability communities. It thus has driven profound reform of global human rights in terms of new ideas, rules, and standards. It advances the group protection of disability rights to individualized assessment by defining the the denial of reasonable accommodation as discrimination. The CRPD has also enlarged the scope of states' positive duties to protect human rights, such as the equal access to justice with person with disability in Article 13. It's fair to argue that the impact of the CRPD is far beyond the boundary of disability rights and reaches the core of humanity. It breaks the institutional and ideological chains, rebuilds the conception of individual autonomy and the right to support, inspires all of us to take the universal vulnerability and the fragility of goodness as fundamental human conditions, and rethink the very first question of how to treat the human being as a human being. This is how the CRPD contributes to the cosmopolitan idea of justice, to borrow the concept of the special rapporteur of the rights of persons with disabilities, Professor Gerald Quinn, the cosmopolitan idea of justice. The CRPD is the most influential human rights document to the China civil society organizations. DPOs and their fellow advocates fully embrace the new concepts of the disability. The human rights model of the CRPD inherits the emancipating force of the social model and empowers persons with disability with a disability identity, supporting them to participate in public decision and influence the policy. People take CRPD to enhance the general understanding of human rights. When some human rights standards was criticized as biased by Western values, people could argue that the CRPD represents a cosmopolitan idea of human rights, sets out humanity's shared values, and creates an innovating paradigm for substantive equality. Does the CRPD imply an alternative mechanism for enforcement of the new paradigm of disability justice and substantive equality? Political science and sociology studies usually employ a triangle of government, market, and society or family to this triangle to discuss the principles of justice and the roles of social members. It's helpful for disability justice too. However, I will propose another triangle of voice, idea, and policy, VIP for short, to highlight the engagement among communities, researchers, and policy makers during the CRPD implementation in China. This VIP triangle helps us practice the four-dimensional frame of substantive equality further and change the world or be the change we want to see. In the past decade, my colleagues and I have taken part in changing process of disability policy in China. We carry out human rights research and education, advocate with communities, and provide consultation to policymakers. We have witnessed pivotal mechanisms such as the annual disability policy forum facilitating such engagement. Professor Carole Petersen and Professor Carole Petersen, they visited Wuhan to take part in that policy forum and dialogue. Firstly, the voice of communities sets out the starting point of policy research and advocacy. However, it needs support from the researchers to comprehend the CRPD and other human rights discourse and transfer the nature and the rightful claims into political, economic, and legal arguments. Secondly, theoretical research on new ideas of disability justice must be informed by the experience of grassroots movements and the concerns of policymakers. The disability rights research has called for interdisciplinary methods for intersectional issues, which foregrounds the exchange between researchers from various disciplines, but also the dialogue among OPDs, Organization of Persons with Disabilities, researchers, and policymakers. Certainly, the traditional top-down policy making has been altered to accommodate the public participation of persons with disabilities. It eventually led to new laws, such as the legal aid law I just mentioned, and the law on the construction of accessible environment due to the impact of the joint efforts of OPDs and researchers. In conclusion, the current practice of implementing the CRPD in China provides a meaningful reference for the empowering approaches to disability justice. It sheds light on the perspectives of substantive equality in a developing country, from general poverty reduction and the welfare provision to individualized equality and the substantive protection. These efforts of interpreting and pursuing disability justice within the context of China have contributed to the global human rights movements or realizing equal freedom for each person with or without a disability. We shall remember that the interaction of diverse human capabilities and just the social rules established the pillars of disability justice. We have used an open frame of substantive equality and to analyze the spheres of disabled justice in the cultural, political, economic, and legal dimensions. We argue for a cosmopolitan justice conception to restore the human in human rights for persons with disabilities. Moreover, joint efforts of disability communities, researchers, and policymakers are crucial to implementing the paradigm shift proposed by the CRPD. We must explore and share the pivotal mechanisms and the best practice that promote such engagement. Together, we shall make disability justice work for all. That's my presentation. Thank you very much. Thank you.
Thank you so much, Professor Zhang. That was just a fantastic address. In a short period of time, you've done an amazing job of educating us on China's history of engaging in disability rights. And I do think China deserves a great deal of credit for being one of the first countries in Asia to enact a law on disability discrimination and for being one of the early countries to ratify the CRPD. But you've also demonstrated the barriers to implementation, and you've, I think, given us hope that there is a lot of potential, particularly with some of the new models you've suggested. I love your voice idea policy triangle, and I love the fact that you demonstrate the relevance of connections. So sometimes those of us who work in academia, we feel that our work might be kind of separate from policymaking work, but in fact, you have bridged those divides and really gotten people together to make a difference. And I really applaud your work and also your wonderful address. So I have many questions, but I'm sure there are other questions as well. Would anyone like to kick off the Q&A?